Mm.
Good afternoon everyone and welcome to this webinar which forms part of the Northern Ireland Planner Live conference series organised by RTPI Northern Ireland. My name is Gemma Jobling and I'm a planning consultant with JPE Planning and currently Vice Chair for the Northern Ireland branch of the RTPI, and I'm delighted to be chairing the session today. To begin with, I'd like to thank our sponsors, RIPS and Landmark Chambers, for helping us make this event possible today. Today's session is entitled How Legal Agreements Can Support the Delivery of Integrated Infrastructure, and we have two excellent speakers, Mr. Yaaser Vanderman and Mr. John Litton, QC, both of Landmark Chambers, who will explore this topic and I've no doubt will raise some very interesting issues for discussion. The overall conference series is considering how we can integrate infrastructure and land use planning, and today's session will consider the use of legal frameworks for legal agreements and specifically developer contributions, and how we might learn lessons from other UK jurisdictions for here in Northern Ireland. Turning to our speakers, I'm delighted to welcome our first speaker, Yaaser Vanderman, a barrister with Landmark Chambers. Yaaser Vanderman was called to the Northern Ireland Bar in 2019, having been one of the Bar of England and Wales in 2012. His practice covers the breadth of planning and environmental work. He has appeared at all levels, including the Supreme Court 4 times last year. Yaaser has a particular interest in environmental issues and infrastructure, and last year he was instructed by Network Rail in relation to the East-West Rail 2 scheme, the £1 billion project to connect Oxford and Cambridge by rail, an inquiry that spanned 4 months. He was also instructed by Quadrilla fracking litigation that reached the Court of Appeal. So I'm delighted to introduce Yaaser today to speak to us. Thank you.
Thank you very much, Gemma. And can I just check that you can hear me?
Yes.
Perfect. All right. Well, excellent. And good afternoon, everyone. And I hope you enjoyed your lunch. As Gemma's very kindly said, John and I will be talking about how legal agreements can support the delivery of integrated infrastructure. We'll be focusing on planning agreements in particular. I'll be looking at the legislative provisions and what they mean in part 1, and John will follow with part 2. All right, so planning agreements and developers' contributions. My experience is that these are relatively underused in Northern Ireland, and that's in stark contrast to my experience in England and Wales, where the equivalent planning obligations under Section 106 of the 1990 Act are routinely used to require developments to contribute to off-site infrastructure cost, including highways, schools, libraries, community centres, public open spaces, and playing fields. And they can be a huge force for good. And as a result, the jurisprudence and the policy approach in England and Wales is more developed. So I'll be looking at sections 76 to 78 of the Planning Act, Northern Ireland 2011, to explore what they provide for and what they require. And then I'll be looking at some case law to demonstrate the limits that you can expect. So here what you see is, very briefly, the English and Welsh legislation. I'll explain to you why it's relevant in a moment. But here you go. So Section 106 of the 1990 Act, where it says any person interested in land in the area of a local planning authority may, by agreement or otherwise, and I've underlined the or otherwise because it demonstrates that not only you can enter into these obligations not just by agreeing with the authority, whoever it is, but you can also undertake yourself by way of a unilateral obligation to do X, Y, Z. Anyway, enter into an obligation enforceable to the extent mentioned in subsection 3, A, restricting the development or use of the land in any specified way, B, requiring specified operations or activities to be carried out in, on, under or over the land, C, requiring the land to be used in any specified way, or D, requiring a sum or sums to be paid to the authority on a specified date or dates periodically. So that's the English and Welsh position. And what you might notice as we go over to the Northern Irish provision, equivalent section 76, is that it is, for all intents and purposes, materially identical, save for one major point, which is that you see underlined, any person who has an estate in land may enter into an agreement with the relevant authority. So you'll see that in the Northern Ireland legislation, the developer cannot undertake a unilateral obligation. It has to be by way of agreement with the relevant authority. But then A, B, C, and D, you'll read, are basically identical to Section 106 in the 1990 Act. And then E is an addition, but is materially to change the position. And then in terms of formalities, going through the mechanics of this, you can see that a planning agreement may not be entered into except by an instrument under seal, which states that the agreement is a planning agreement for the purposes of this section, identifies the land in which the person entering into the agreement has an estate, and identifies the person entering into the agreement and states what that person's estate in the land is. Very important that you comply with those requirements. The case law suggests that if one of those requirements isn't adhered to, then the agreement may well be invalid. So that's the formalities. And then in terms of enforcement, just to show you that this does have teeth, there are three methods of enforcement. First, that you see in subsections 4 and 6, is that a planning agreement is enforceable by the relevant authority against the person entering into the agreement and against any person deriving title from that person. And then that restriction or requirement imposed is enforceable by injunction. So in other words, just confirming that the normal contractual position, normal contractual remedies are available for breaches of planning agreements. But it goes wider than normal contract, because clearly the normal rule on privity doesn't apply here, because not only can you enforce against authority enforce against the person that they contracted with, but also the person who derives title from that person. Second method of enforcement you see at the bottom in subsection 12, which is that sums to be paid are deemed to be a charge on the estate, enforceable as if a valid mortgage by deed. And then over the page, the last method of enforcement, if there's a breach of a requirement in the planning agreement to carry out any operations in, on, under, or over the land to which the agreement relates, the relevant authority may enter the land and carry out the operations and recover from the person or persons against whom the agreement is enforceable any expenses reasonably incurred by it in doing so, and those expenses shall be a civil debt recoverable summarily. So that's the method of enforcement. That's section 76, and then just very briefly touching on sections 77 and 78. These deal with modification and discharge of planning agreements. And you can see that section 77 says a planning agreement may not be modified or discharged except by agreement between the parties or in accordance with the rest of that provision. And subsection 3 confirms that if parties want to agree with it, then it has to be contained in an instrument under seal. I'm not going to go into too much detail, because the purpose of this talk and series is to talk about how we further these developers' contributions and this kind of thing. So this is slightly peripheral, but I think it's important to at least know that, be aware of it. And section 77.4 talks about being able to apply to discharge planning agreements after the expiry of the relevant period, and the relevant period is 5 years. And you can see at the bottom in subsection 7, you can see what the test is that the local authority will have to apply, which is whether the agreement serves a useful purpose still. And then very briefly, section 78 just allows for an appeal if following an application that's refused by the relevant authority, or if it's not determined, and appeal lies to the Planning Appeals Commission. So that's the legislative position. What does it all mean, and where do the boundaries of acceptable planning obligations lie? Well, the answer, or a very useful answer, is in the Aberdeen City case. And I know what you're thinking, this is a Scottish case, how could it possibly be relevant? And I know you're thinking that, frankly, because that's what I always think when I come across a Scottish case. But the answer is it's highly relevant for 3 reasons. 1, it's a Supreme Court case. 2, the Scottish legislation is very similar to the English and Welsh legislation, and indeed in the Aberdeen City case, the Supreme Court said those regimes were substantially similar, such that they applied the English jurisprudence when deciding this case. That's paragraph 43 of Lord Hodge's judgment. And 3, the reason why it's relevant, is because the Northern Irish legislation is virtually identical to the English and Welsh legislation. So one can be pretty clear, pretty confident that the analysis in this case will be relevant, very useful in interpreting what is allowed under Section 76 of the Northern Ireland 2011 Act. So what were the facts in Aberdeen? You can see that from the first bullet, the authority in that case adopted supplementary guidance and essentially wanted to set up a strategic transport fund in order to finance a set of infrastructure projects, transport projects in the area. And they effectively required developers to pay financial contributions, which were in addition to mitigating impacts specific to those developments. And then they would pool those contributions to deliver transport projects in and around Aberdeen. And the contributions were fixed by reference to unit size. So, for example, a developer had to pay £1,350 per 1-bedroom unit, and the same double for 2-bedroom units, etc., regardless of the specific impact of that unit on the surrounding transport links. And moving on to the next slide then, there are some general points that Lord Hodge made in that case. I should say it was unanimously decided. Lord Hodge's judgment is the only judgment in the case. And he said, prima facie, the authority has wide discretion as to when and what planning obligations it can see, which is good because it gives the authority flexibility in order to make those contributions as useful as they can be. And the limits to that, because obviously you couldn't ask for anything, but the limits were the words of the statute, so you couldn't go outside the words of the statute, obviously. Second, it had to be done for a planning purpose, couldn't be done for some ulterior purpose. And third, the obligation couldn't be Wednesbury unreasonable. So relatively light touch, but there were limits, they weren't too strict. And then he said this at paragraph 41, a planning authority may contract for the payment of financial contributions towards, for example, educational facilities, healthcare facilities, sewerage or waste and recycling, requiring a development to contribute to or meet its own external costs in terms of infrastructure involves regulating the development of the land which is burdened by the obligation. The financial contribution can be applied towards infrastructure necessitated by the cumulative effects of various developments, so long as the land which is subject to the planning obligation contributes to that cumulative effect and thereby creates a sufficient relationship between the obligation in question and the land, so that one can fairly speak of the obligation as regulating the development of the land. So I think that's useful in understanding exactly what the connection has to look like. So going back to the Strategic Transport Fund, the issue Lord Hodge highlighted in this case was, is it lawful by planning obligation to restrict the commencement of the development of the site, so until the developer undertakes to make a financial contribution towards infrastructure, and this is the crucial bit, which is unconnected to the development of the site? And the answer, unanimously, was no. And that was for the following 4 reasons. First, it would undermine the authority's obligation to determine an application on its merits. Second, the wording of the statute contains an implicit limitation. The restriction must serve a purpose in relation to the development or use of the burdened site. An ulterior purpose was not allowed. Third, in allowing that approach, there was a risk of forcing developers to incur disproportionate costs because the local authority basically would have a ransom. And fourth, there was the risk of creating an impression that planning permissions were being bought. And the last 2 of those, the court was particularly concerned about bringing the planning system into disrepute. So looking specifically at the Strategic Transport Fund, which was found to be unlawful, the reason why it was unlawful was because there was no more than, this is the wording used by Lord Hodge in paragraph 61, no more than a trivial connection between the developments on the one hand and the use of the developer's contribution on that infrastructure on the other. And he highlighted these factors. You can see at the bottom 4 bullets. There was no single developer was liable for the cost of any specified interventions, i.e. pooling. The obligation to contribute to the fund was in addition to the requirements that that developer mitigate impacts specific to the development. The contributions were fixed at a sum per unit. Again, breaking up the relationship between the impact of a unit on the transport links. And finally, the payments weren't tied to the impact of a particular development on transport network. We see that point at paragraph 56. So that's, I think those are all factors, and the reasoning in the case is useful to know exactly what developers' contributions can go towards, what a local authority can require. There's always going to be a grey area in the middle, and there'll be a judgment call, but I think this gives you some useful guidance on that. And just a final point, remember the difference between the validity of a planning obligation, which is what Aberdeen was talking about, and which I've been focusing on, the wordings of the statute, and on the other hand, whether it can be a material consideration when an authority comes to make a decision. And paragraph 52 of Lord Hodge's judgment is useful on this, where he said it's important to recall that the question whether a benefit conferred by a planning obligation is a material consideration in the determination of an application for planning permission is quite separate from the question whether a planning obligation restricts or regulates the development or use of a particular piece of land. Thus, to use the example of the farmer with two farms A and B, and just by way of background, this is an example he previously used. He wishes to develop Farm A and is prepared to enter into a planning obligation to restrict the development or use of Farm B in the context of his negotiation of a permission for Farm A. The legality of the planning obligation in relation to Farm B will depend, among other things, on whether it restricts or regulates the development or use of Farm B. The relevance of the planning obligation to the determination of the application in relation to Farm A depends upon there being a more than trivial connection between the benefit conferred by controlling Farm B and the development of Farm A, as the Tesco case decided. So just be aware of that difference, and I'm aware that I think John is going to talk more about the material consideration side of things in a moment when he comes to his talk. So what is the takeaway? Well, I think John will talk a bit more about this, but in practical terms, planning agreements and developers' contributions can achieve a heck of a lot. And what's more, authorities have a wide discretion in deciding on what planning obligations that they seek. But beware of the three limits identified by Lord Hodge, and beware of being too ambitious and the pitfalls identified in the Aberdeen case on the validity of a planning obligation. Thank you. That's the end. And if I pass back to Gemma.
Thank you, Yaaser. That was very, very interesting. And probably at this juncture, I just take this opportunity to remind everybody that throughout the session today, I'd encourage you to submit questions if you can. You'll see at the bottom of your screen where you can submit questions, and I'll be keeping an eye on those through the rest of the session. And then at the end of John's presentation, we'll do a collective sort of Q&A. So you're not off the hook yet. Yeah, there are still a few questions to answer, and we can delve into those and have, I think, a really useful and conversation around the use of developer contributions. And also, please remember, I should have said this at the beginning, but please remember if you are tweeting to use the hashtag NIPlanLive2020. And thanks very much. So turning on to our second speaker today, I'm delighted to welcome John Litton QC, who's also a barrister with Landmark Chambers. John Litton was called to the bar in 1989 and took silk in 2010. He was then called to the Northern Ireland Bar in 2013. His plan and practice includes promoting infrastructure developments such as strategic rail freight interchanges, renewable energy projects, guided busways, new roads, and major highway improvement schemes, which I think will be interesting as we move forward in the next few years here. He also advises on DCOs, development plans, and has appeared at numerous examinations in public. He has considerable experience across all aspects of planning enforcement, and John has represented the Department for Infrastructure, Northern Ireland, at a public inquiry before the Planning Appeals Commission in relation to an application for a proposed 400 kilowatt overhead electricity line connecting the electricity grids of Northern Ireland and the Republic of Ireland. So on that note, and without wasting any more time, I'd certainly like to welcome John Litton QC. Thank you.
John, your mic is muted.
Can
Yes,
everyone hear me now?
Yeah, go ahead.
Sorry, let's reset. Yes, just picking up then from where Yaaser left off. Section 106 agreement in England is a legally binding agreement negotiated generally between the developer and the local planning authority to address concerns that an authority may have about meeting the costs of providing new infrastructure. And in England, 3 legal tests have to be met before a planning obligation can be used. And these are set out in what is Regulation 122 of the Community Infrastructure Levy Regulations, which provides that a planning obligation may only constitute a reason for granting planning permission for the particular development if that obligation is first necessary to make the development acceptable in planning terms, directly related to the development, and lastly, fairly and reasonably related in scale and kind to the development. And as Yaaser has already said, Section 106 agreements are routinely used to secure financial contributions towards affordable housing, education, including the provision of new schools, health provision, highway infrastructure, public transport infrastructure and services, sports facilities, etc. But they can and are also used to secure environmental and ecological improvements. And for larger developments, particularly housing schemes, these contributions can and do run to often very many millions of pounds. The policy for the use of Section 106 agreements in England is set out in 2 policy documents, the National Planning Policy Statement, February 2019, and then the National Planning Practice Guidance, which is frequently updated. And in England and Wales, there have been many cases at all levels, including the Aberdeen case that Yaaser referred to, relating to the use of Section 106 agreements. Turning then to the position in Northern Ireland, the policy on the use of Section 76 agreements is set out in 2 particular documents, and in chronological order, these are firstly the Strategic Planning Policy Statement published in September 2015, and secondly the Development Management Practice Note published in January of 2017. If I just turn first to the Planning Policy Statement, it makes the general observation that planning authorities can use planning agreements to overcome obstacles to reflect to the grant of planning permission where these cannot be addressed through the use of conditions. And reflecting the provisions of Section 76, it says that the planning agreement may facilitate or restrict development or use of the land in any specified way, require operations or activities to be carried out, or require the land to be used in a specified way, and importantly, it can require a sum or sums to be paid to the relevant authority or to a Northern Ireland department. It goes on to say that a planning agreement may be appropriate where, as I've indicated already, it cannot be adequately addressed by the imposition of a condition, and then sets out a number of bullet points which are important. One is that it's needed to enable the development to go ahead, and that really reflects very much the first of the SIL tests in England and Wales. Secondly, will contribute to meeting the costs of providing necessary facilities in the near future. Thirdly, is otherwise so directly related to the proposed development and to the use of the land after its completion that the development ought not to be permitted without it. Again, that reflects very much SIL tests 1 and 2. Fourthly, is designed to secure an acceptable balance of uses. Fifthly, is designed to secure the implementation of development plan policies in respect of a particular area or type of development. Or lastly, is intended to offset the loss of or impact on any amenity or resource present on the site prior to the development. And these matters are evidently more extensive than the 3 SIL tests in England and would allow, it seems to me, for a Section 76 agreement to be entered into in a broader range of circumstances than a Section 106 agreement. The policy statement goes on to make the point that a developer will be expected to pay for or contribute to the cost of infrastructure that would not have been necessary but for the development, or which needs to be rescheduled to facilitate the development. In other words, if an infrastructure upgrade is not necessary but for the development proposed, or that infrastructure is planned for a future date but has to be brought forward earlier than scheduled because the proposed development would have an unacceptable impact without that infrastructure being in place sooner than proposed, then the Section 106 agreement can make financial provision the Section 76 agreement can make financial provision for that. It makes a distinction between developer contributions and community benefits, and that's going to be of some relevance when I look at a couple of cases. And makes the point that planning authorities can require developers to bear the costs of works required to facilitate their developments, and sets out a number of circumstances in which that might be the case. But then it makes a distinction between that and what are referred to as community benefits. So it makes the point that community benefits may be offered voluntarily by developers to communities likely to be affected by a development. And indeed, those community benefits can take a variety of forms, including payments to the community, etc. But the policy statement makes very clear that such community benefits are not material considerations in decision taking and are distinct from the developer contributions that might be secured through the Section 76 agreement. The second strand to the policy is the Development Management Practice Note 21, published in January 2017. It makes a general point that no two developments or applications are identical and that circumstances will vary on a site-by-site basis, and so they have to be approached in an individual way. It reflects the policy that is found in the earlier policy statement, and then looks again at contributions, both in terms of developer contributions, which is very much reflective of the policy statement, and then voluntary contributions. And in relation to that, it says this: in some circumstances, community benefits may be offered on a voluntary basis by developers likely to be affected by a development, but makes the same point as is made in the policy statement, that these are not considered to be material considerations and are distinct from developer contributions and planning conditions. It does then set out a number of guiding principles which broadly reflect the SIL tests, and these are then set out in rather more detail under a series of headings addressed to need, the contribution to costs, and the like. One thing to just highlight is that the policy does make clear that negotiations on planning agreements may wish to take cognizance of the development viability. That's a bit possibly cryptic. Certainly in England, it's of some considerable importance because many schemes, particularly the housing schemes, are required to provide affordable housing. And particularly in the context of schemes that are proposing to provide less affordable housing than perhaps the local plan requires, satisfying local authorities that a scheme is financially unviable if the full amount of affordable housing is provided is often contentious. And so with larger schemes, which are intended to be phased and built out over many years, the viability of those schemes often changes. And consequently, in England, Section 106 agreements frequently have viability review mechanisms included to allow the viability of that particular scheme for which permission has been granted to be reassessed over time. And for example, for the affordable housing component to be increased if in later phases the viability of the scheme improves. And so that's an important point which can be incorporated into Section 76 agreements as well. The it has to be directly related, and this is important and goes to the question as to whether it's a material consideration. So the planning agreement should relate to the development being proposed, such as where a proposed development would create a direct need for particular facilities or place additional requirements on infrastructure. And there has to be a link between the development and any mitigation offered, including any financial contribution. In terms of cases, there is one particular case in Northern Ireland, which is the Conlon and Belfast City Council case, decided in 2018. That was a case that some of you, I suspect, may be familiar with, and arose out of the grant by Belfast City Council of permission for the redevelopment of the Market Quarter, and which was challenged by Ms. Conlon, amongst other things, on the basis that a Section 76 agreement secured £230,000 worth of financial contributions towards, it was said, the cost of public infrastructure, and which she said was effectively not related to the proposed development. Mr. Justice McCloskey, in looking at that, reviews both the statutory provisions in Section 76, but also both the Management Practice Note 21 and also the policy statement, and makes the point that the exercise of understanding and evaluating the policy note is aided and illuminated by the policy statement, and this makes clear that these two policy instruments must be considered in conjunction with each other, and that the purpose of a Section 76 planning agreement is to overcome obstacles to the grant of planning permission where these cannot be addressed through the use of conditions, but making a distinction, as is made in those policy documents themselves, that there is a difference between developer contributions and community benefits. He was then satisfied that in that particular case, the financial contributions secured through the agreement did indeed relate to developer contributions and were not simply community benefits. There is those who have perhaps looked at the Practice Note 21 will have noticed that there's a footnote 3 to paragraph 4.5 of that note, which refers to an English case called Wright and the Forest of Dean District Council. And the date for that is 2016. Now, that's the first instance decision of that particular case. And it's important because it looks at the whether or not voluntary contributions are material considerations. And it's just important to know that that case has now gone up to the Supreme Court, was heard by the Supreme Court in July of last year, who gave judgment in November of this year. And Lord Sales, paragraph 42, sets out, I think it's an important passage, saying this: a principled approach to identifying material considerations is important, both as a protection for landowners and as a protection for the public interest. It prevents a planning authority from extracting money or other benefits from a landowner as a condition for granting permission to develop its land, when such payment or the provision of such benefit has no sufficient connection with the proposed use of the land. It also prevents a developer from offering to make payments or provide benefits which have no sufficient connection with the proposed use of and as a way of buying a planning permission, which would be contrary to the public interest. So again, it's just this tension between treading the right line. If you're a local authority, not asking for financial contributions that might be nice for the local authority to have, but are not related to the development. And on the other side of the coin, applicants for planning permission not thinking that they can effectively buy their permission by offering benefits, which again are unrelated to the development they are proposing. So, I mean, Section 76 agreements undoubtedly provide a valuable mechanism allowing development to proceed, which would otherwise be refused permission because of its impact. But it does have to be used properly and not by developers as a means of buying permission. Equally, local authorities should not use it to extort money or benefits from the landowner. Voluntary contributions of benefit to the community can be made, unless they meet the tests, cannot be taken into account when deciding whether to grant permission. And so just going back to the right case, in that particular case, the proposed development was a single turbine intended to be secured with a condition which generated a percentage of the turnover of that turbine to be distributed to the local community for the local community to decide how to spend that money. And that was regarded as effectively a community benefit, which was not a material consideration in determining whether permission itself should be granted. So I think with that, thank you very much indeed. I think we're going to come back to Gemma, and she is going to field any questions.
Thank you very much, John. That was very helpful. It certainly got my mind thinking of a few examples, and interested to learn a wee bit more about the connection between community benefits and developer contributions, and where the two may be offset, and where a community benefit does become a material consideration in the delivery of, or in the provision, I should say, of developer contributions. Is there any instances, or are you aware of any real instances where community benefit infrastructure, for example, whether it's the provision of, for example, a play park or a community space, has been considered material to offset the proportion or the amount of developer contributions for a particular scheme?
Yeah, you're quite right, Gemma. The answer is it's a pretty grey area, and certainly what you find in England and Wales is that at an application stage, local authorities, notwithstanding all the policy background to this, will often ask a developer for a contribution for example, an additional open space. And they'll say, we need £50,000, £100,000, whatever it is. Now, I mean, often that is more than is needed to offset the impact of the development, and that additional open space will have obviously a broader benefit to the community than just the development that's being proposed. So there's always an overlap between meeting the impacts of the particular development and also then providing some broader public benefits. There's nothing wrong with that at all. The difference, as you say, is, but is it proportionate? As I say, at the application stage, more often than not, a developer will say, well, if agreeing to provide £100,000 contribution towards public open space is going to get us a recommendation for the grant of permission, then you will find developers say, we'll just go with it, and they won't question the amount very closely. It starts to get contentious when, for example, local authorities perhaps start getting greedy, or there are other reasons, and perhaps it goes to appeal. And whereas a developer might have said at the application stage, well, I'm prepared to accept to paying these sums of money if that gets me a recommendation to grant permission. But if I've got to now fight this at an appeal in Northern Ireland in front of the PAC, then I'm not going to be rolled over. And we're now going to test whether or not these sums are actually proportionate.
Okay, that's very helpful, thank you. We have been, questions are coming in thick and fast. Thank you to everybody, and please do continue to submit any questions that you might have. We have probably about another 20 minutes or so to get through some questions and answers. So a couple that came through, maybe John, during your presentation, one question was whether many of the infrastructure providers in Northern Ireland, for example, education, roads and water, sit outside of the remit of the local planning authority. Should the relevant department or provider be a signatory to the agreement?
I mean, almost certainly yes, because at the end of the day, it is a contract. That's the nature, the legal nature of the document. It is a contract, and therefore, for it to be enforceable, you need the party to whom the sums of money are going to be paid to be a party to that contract, so they can indeed enforce it contractually.
Thank you. And then moving to Yaaser, a couple of questions coming through. The first one, are there any situations in Northern Ireland where unilateral undertaking may be appropriate, or are you aware of any examples of it being used elsewhere?
Well, the funny, I mean, that, can you hear me, Gemma?
Yes, I can indeed.
I was looking at the Belfast Council local, the plan in Belfast, and that does refer to developer contributions and even refers in terms of unilateral undertaking. But having said that, the legislation specifically refers to agreements, unlike the English legislation. So it's not clear to me how unilateral undertaking would be relevant to the decision-making process. So I don't know if you have any views on that, but the difference in legislation, in my view, in my understanding, means that unilateral undertakings don't have really a place in the regime.
I mean, I think that's right. I mean, it is a distinction between the position in England and Wales and Northern Ireland, as Yaaser says. Section 106 specifically makes provision for unilateral obligations. Indeed, that's why we refer to them not simply as planning agreements, but planning obligations. And it's not uncommon in England and Wales that a local planning authority who perhaps is against the principle of the development or the particulars of a particular application refuses to enter into a planning agreement. They say, well, we're not prepared to do that. And the additional facility that Section 106 has in England and Wales is that developer can say, well, that's fine. Well, I'm going to enter into a unilateral obligation, which will ensure that you get these sums of money in any event, and the enforcement mechanisms apply to both agreements and also unilateral obligations. As Yaaser says, I mean, the reference is to agreements, which seems to exclude unilateral obligations in Northern Ireland. I'm not sure that necessarily means that it's impossible to enter into, as long as you can do it legally outside of the mechanisms of Section 76. Whether or not it's a material consideration seems to me would have to be tested against whether or not an agreement would meet the tests of being material. So if you could find a mechanism, a legal mechanism, whereby you could offer a sum of money, and as long as that sum of money was intended to be paid to offset the impacts on education or impacts on the road from that particular development, it seems to me it would be a material consideration to be taken into account by the decision maker. And the question then would be, is this a valid or a legally valid unilateral obligation? And that's really the distinction that Yaaser was making in terms of the Aberdeen case between the validity of an agreement, and whether or not it's a material consideration to be taken into account when you decide whether or not to grant a planning permission.
Okay, thank you. That's been very helpful. Another question, I suppose, maybe picking up on something, Yaaser, you mentioned in terms of the local development plans coming through. We have a question regarding that and the impact. As councils in Northern Ireland prepare their local development plans, and we're starting to see the emergence of policies which will seek to secure affordable housing contributions by way of a legal agreement, given that the affordability issues are pre-existing and not always a direct impact of development, how can it be demonstrated that they are so related to the development that the development not ought to go ahead or not to be permitted, I should say, without it? And could affordable housing be secured by condition, as it would be a policy requirement?
John, I think you were referring to affordable housing in Section 106 earlier. I don't know if that's something that you want to pick up on.
Yeah, I mean, it wouldn't normally be dealt with by way of a condition, because affordable housing is in a sense rather more sophisticated. I mean, affordable housing certainly in England embraces a broad basket of tenures. We have affordable rents, we have affordable ownership, we have all sorts of different models of affordable housing. And so affordable housing contributions are generally always dealt with through the Section 106 agreement and the financial contributions that might be paid through that. Because again, affordable housing might be provided on-site as part of a particular housing development, or in some cases, it might be a contribution to the affordable housing, which is actually be provided off-site. So it can get quite sophisticated. I think if I'd understood the earlier part of the question, the various councils are now producing their local plans, and they are looking at policies relating to the provision of affordable housing, which I think is quite right. And when you look at the practice note and indeed the policy statement, it also advises councils to relate their requests for financial contributions to their policies. So it's right that those policies should be in the plans. I'm not sure I quite followed the sort of tail end bit of that in terms of affordability.
I suppose it was asking whether, given that those requirements will be within the plan, is it a requirement then for developer contributions on top of that, or to specify the need for affordable housing through a legal agreement, or is it within the plan enough? I think that's the question's getting at.
Yeah, well, if you have policies in the plan, it gives you a better hook for requesting those affordable housing contributions or requiring that amount of affordable housing to be provided as part of a development. Because, again, as part of all this, I mean, if you're going to ask developers for contributions, whether it's a percentage of the residential units to be provided as affordable housing or a financial contribution or a bit of both, it should be rooted in some sort of evidence base. The point about a policy in a plan which says, you know, we will look for 25% affordable housing as any part of a housing scheme, that policy has been through a public consultation process, it's been through some sort of examination, has been formally adopted. So it's a starting point and provides obviously a very powerful hook for that local authority then to ask for the affordable housing contributions that it wants to in relation to a particular scheme. So it is an important part of that. Now, whether or not a local authority can ask for more than its policy requirements, I suspect it's going to struggle because, again, just come back a step. It is supposed to be related to and not be disproportionate to the impact it's going to have. So if you've got a policy that says 30% affordable housing, and then on a particular scheme you say, actually, we want 50%, you as a council might have a tough ask to justify that.
Thank you, John. Another question coming through, although I think this may have been picked up on by both of you, but I'm going to direct this one to Yaaser to start with. Does the provision for sums to be paid to Northern Ireland departments mean any government department, and would they need to be a signatory to the planning agreement? Would it extend to agencies of the Northern Ireland departments? And examples that have been given, the Northern Ireland Housing Executive, which takes us back to the affordability issue, but also Invest Northern Ireland, who are quasi-government organisations for the sort of economic development side of things.
I think the first question, does it refer to all government? I mean, I think I need to double check, but I would have thought of that as the Department for Infrastructure, but I'm not entirely sure. But again, I would have thought that it should be a signatory to the planning, to the agreement, for the reason that John's already said.
Okay.
Yeah, I mean, I would have to just double check. I don't think Northern Ireland departments is defined in a way which limits it to only certain Northern Ireland departments. So I think in principle, any Northern Ireland department could be party to that particular agreement. It goes back to the original question. So, you know, is what that department is asking for, is it related to the development, is it necessary, etc. If it's not, if it's completely unrelated, it's just a government department that says, you know, we'd like X thousands of pounds for whatever, and it doesn't meet the sort of tests, then no, they shouldn't be a signatory. Then they shouldn't be asking for that money in the first place. I mean, I see, Gemma, there is a question at the end of here which asks, new developments are often criticised as car dependent. Could funding for off-site safe walking and cycling infrastructure and bus connections be provided by Section 76 agreement? I mean, I think the answer to that is absolutely yes. Again, as long as it's dependent. I mean, certainly a phenomenon that you see here is increasingly, particularly town centre or city centre developments, aren't providing any parking at all. Purpose-built student accommodation schemes, for example, where you might have 500 residential units for students to attend university, and it provides 6 car parking spaces. And the quid pro quo to that very often is financial contributions made to improving cycleways in the vicinity, dedicated cycle paths, cycle parking. I've done cases where contributions may be made to car clubs, car sharing clubs, so that again, all off-site infrastructure in the streets, etc. Very often, Section 106 contributions are used to fund new bus routes, new bus shelters, new signage for buses, information, real-time information, and that kind of thing. All sorts of things to improve non-car transport, basically, sustainable forms of transport. So I think the answer to that is yes, and I would expect Section 76 agreement to be used very much in that way.
Okay, thank you. Certainly something that we would see quite regularly in terms of the use of contributions to both the Department for Infrastructure for roads, but also, as you say, to TransLink, which would be the sort of local provider here for bus routes, and that would be fairly standard, I think. But we're starting to see a bit of a expansion of where it can be used, and I think it's been very interesting today, and I'm sure there's quite a few people that have been listening that it's triggered a few thoughts in terms of how they might explore the use of developer contributions in the future. There's one final question that I think might be a nice one just to finish on, and it's to do with the return of money of developer contributions. So I'm not sure, I'll ask the question first, and then John or Yaaser, either of you want to jump in. So it asks, some developments have made developer contributions to local authorities already, and have perhaps been with the planning authority with the local authority for a few years. The agreements contain clauses that the money will be returned if not spent after a period of years. If the sum of money is required to make the development acceptable, is this undermined by the return of the money after that period of time? John, I can see the reaction in your face, so I might come to you first if you don't mind.
Well, I mean, it's a perennial debate that we certainly have. You generally see those kind of clauses where, for example, an applicant has agreed to pay X, Y, and Z. They're not necessarily convinced that it's an appropriate sum of money or whatever. They're maybe suspicious that the local authority just hasn't got the wherewithal to actually carry through or do the infrastructure improvements that they say are necessary with the money they're being given. And the developer doesn't want to hand over £100,000 to a local authority only to find that the infrastructure which it's supposed to be funding never comes forward. And so they often agree a clawback of that money if that money is not spent after a period of time. I mean, I think it cuts both ways. I mean, that in some cases it's necessary because if it's a cumulative impact from a number of different developments, me paying £100,000 is not going to provide that new bridge. It actually requires contributions from 6 other developments as well, all paying £100,000, and then you've got a pot of £600,000-700,000. Maybe you can do it. But it does provide also an incentive on the local authority to get on and spend that money. And if it is recovering money from the private sector for infrastructure which it says is necessary, it does seem to me that there is then an onus on that local authority to spend that money providing the infrastructure which it said was necessary. So it's a sort of carrot and a stick approach, I think, and that clawback does provide some incentive on the local authority to get on with spending the money that it's collecting money for.
Yeah, I think certainly answers that, and I think a lot of people be going back to their desks and just checking the time that they have left on those agreements and think if they start need to get plans in place to organise the payment of sums. But unless I think that's probably us coming to an end, and I think that's been really helpful and really interesting, and I'm sure a lot of people have got a lot out of this. I'd like to take this opportunity to thank both of our speakers today, who have been excellent and really have given us some valuable information, both in terms of provision of case law and giving us a real walkthrough on the legislative context, both here in Northern Ireland and also in the rest of the UK. So thank you firstly to Yaaser Vanderman, and then secondly to John Litton QC. I'd also again like to take this opportunity to thank our sponsors, RTPI and Landmark Chambers. And on that note, thank you to everybody for coming along today. And again, if you're tweeting about today, please remember to use the hashtag NIPlanLive2020.